Hi, everybody. We're very happy to be here, and what an amazing crowd. I wonder how many are appearing by video, or is anyone else? Oh, it's just a video, there's no live. Got it. Well, thank you all for being here. We are going to talk about the accommodation called representational accommodation, or suitable representative in administrative hearings. And true to form, I hope, following what Laura Bradley said, we have actually some learning goals for you. And it's sort of in bullet point, and we hope we meet these goals. So first, we want to explain to you the legal history of representation as a disability accommodation in hearings. We're going to then hope that familiarize you with the concept. What does it mean? How does it work? We hope at the end you'll be able to recognize, and this is probably our biggest goal, is in the hearings that you preside over, that you'll be able to recognize when an appellant or a party might need representation as an accommodation in that hearing in order to access the hearing process that you preside over. We want to also hope that you'll see what are some of the implementation issues of providing representation in hearings using the Office of Administrative Hearings new rule. And then to consider or think about how is your agency, the agencies for which you hold hearings, dealing with this issue at all, if at all, when it comes up in your hearings, and what improvements might be able to be made. So those are our goals. So we're going to start out, I want to give you a quick history. It's really an amazing history of the legal history of accommodation of legal representation, because we think it'll help you understand the rule, the new rule, and also how you might consider accommodating appellants who appear in your hearings. And by that, and if the appellants or party is too disabled to represent themselves at the hearing. That's what we're talking about. So the first case that raised this issue was in Moses Lake in 2002. Way back in 2002. And it was a case, Smith versus Moses Lake. Yeah, come on in. Welcome. Throw a little humor into your presentation. This was way back in 2002. It was a Washington State Supreme Court case. And I want to tell you Mr. Smith's story. He was an elderly man who owned a home in Moses Lake, Washington. And he lived there for over 50 years. His home was the only significant asset that he had. Moses Lake City brought an action in Superior Court to tear down his home. That's because his home did not comply with the building ordinances there. It was in extreme disrepair. And so they were essentially condemning it and wanted to tear it down. Mr. Smith was a person with significant disabilities, physical and mental. He was electrocuted while working as a carpenter in the 1950s, and as a result, he suffered from impaired mental functioning. And here's what the record said. He was diagnosed with a mood disorder with mania due to electrocution, which prevented him from organizing his thoughts and comprehending complex matters in the courtroom. He was very easily distracted. He had difficulty even completing the simplest tasks around the house. He was easily overwhelmed with complex cognitive tasks due to his distractibility and impulsivity. His disabilities were at a level where he qualified for a Social Security disability. When he got to the courthouse in Moses Lake to try to fight the demolition of his home, he was simply unable to put on any case at all. He didn't understand what was happening beyond that his home was going to be taken from him. He knew he didn't want this to happen. He was able to express that, but he was at a total loss about what to do. Mr. Smith asked the judge for a lawyer, but the judge dismissed his request outright and just began the hearing. During the proceeding, Mr. Smith, his presentation consisted of asking the court to please restore his water and power to the home. That's all. He was confused by the entire proceeding, and finally the judge did order his home demolished. So those are sort of the facts of what happened at his hearing. This case was appealed by Northwest Justice Project to the Washington Supreme Court. And they asked, I teach an administrative law clinic, they asked us to consider filing an amicus brief or filing a brief with them about whether Mr. Smith should have been provided with counsel at this hearing. Northwest Justice Project was arguing under Washington State's Constitution that the due process clause required representation for him in order to have a fair hearing. But we began to think about it from a different point of view than a constitutional issue. We had seen so many clients and litigants, both in courts and even more so in administrative hearings, who looked like Mr. Smith, who, because of their disabilities, could not understand what was going on in the proceeding or could not meaningfully participate in the hearings because of their mental or physical disability. They couldn't understand, or they were physically unable to sort of have the energy to muster a case. So for example, clients with dementia or mental health issues that affecting, or ADD, affecting ability to concentrate, or who were so physically impaired from, say, heart disease, that they couldn't, it was too dangerous and too hard for them, and they were too anxious to put on a case. Not due to education, lack of education, or language issues or illiteracy, no, because that's not because of a disability, but because of a disability couldn't participate. So our theory was that the Americans with Disability Act provided a remedy for people like Mr. Smith, that they could only, that their access to the court must be accommodated through representation. Just like through a lawyer or a trained representative. Only a lawyer, like a reader for people who are blind, or like a sign language interpreter for people whose disabilities cause them to be unable to meaningfully participate, only a lawyer or a legal representative would accommodate that kind of disability. That was our theory. So sadly, Mr. Smith died before the Supreme Court could hear the case back in 2002, and therefore it was mooted out. But the argument was there and it had resonance. So we wrote an article for the Seattle Journal for Social Justice and created a group of advocates who wanted to fight for what we called civil Gideon, the right to counsel in civil cases. So the amazing part of, and this group was called Circle. The amazing part of this story is that Circle, via articles and presentations and advocacy, was able to work with and ultimately convince the state Supreme Court to adopt a rule, General Rule 33. And that was a rule that set out ways for courts, judicial branch courts, to accommodate people with disabilities, all kinds of disabilities. The amazing part was that it specifically defined an accommodation to include, quote, representation by counsel. This was like a miracle. We got representation by counsel in the rule as one of the accommodations. This was 11 years ago. It was the first in the country Supreme Court that created such a rule. So now the judicial branch courts had a process to assess and evaluate the need for representational accommodations under the ADA and Washington law against discrimination. But the administrative branch, the executive branch courts, didn't have a similar rule. What we found out from GR 33 was that all of the arguments made against providing this kind of accommodation really were wrong. Pierce County embraced GR 33 and provided it. And what did we find? There were no floodgate of litigants who wanted this accommodation. It was fairly rare. There were some, but it wasn't a lot. The costs were not huge. The provision of representation made it more efficient, made for more efficient use of the court system. And I'll bet you know this, the judges loved it. right? It is not easy when appellants like these, or parties come before you with these kinds of disabilities and can't put on a case. Your job is made so much harder, and it's not fair. And people recognize this. So we then move to argue that administrative courts should adopt an assessment process just like GR 33, since the ADA and WLAD applied equally to all the executive branch courts. There's no difference, state government, right? So two big cases helped us move this forward. One was Franco Gonzalez, which was a federal district court. This was the biggest case. In Franco Gonzalez, the U.S. District Court held that a class of disabled immigrant detainees were entitled to appointment of qualified representative in their removal hearings under the Rehab Act. As you may know, the federal immigration courts are administrative courts. They're not judicial branch courts. And this case, for the first time, held that representational accommodation was required. This was a big win, and the first to hold that it was available in administrative branch courts. The second big case was Wiens versus the Board of Industrial Insurance Appeals. That was a state court case, and this case showed the real grave disparity between the judicial branch courts and the administrative courts in providing a representational accommodation. What happened, and it's very briefly, was that a worker was bringing a claim for workers' compensation benefits to reopen due to his worsening injuries caused by a 1973 accident on the job. He had a brain injury. He was denied, he told the judge he was unable to represent himself due to the brain injury, and the judge denied a representational accommodation, went on with the hearing, and then denied his claim. He sought judicial review in the Thurston County Superior Court, and lo and behold, under GR 33, the Superior Court appointed counsel as a reasonable accommodation under the ADA after doing an evaluation. So the judicial branch court found he needed it, and then he had his case remanded back to the board, and there was no accommodation provided there because there wasn't a process. So we had this and then it was appealed back up to Superior Court after he lost again, and finally up to the Court of Appeals on the issue of whether he was denied due process and an ADA accommodation due to his disability. The Court of Appeals remanded the case back to the Superior Court to make specific findings of fact on Mr. Wiens' need for a representational accommodation under the ADA. So they essentially said the ADA, yes, it applies, and see if there's a representation as the appropriate accommodation. On remand, the Superior Court found, yes, under the ADA, the agency had violated its affirmative obligation to conduct a fact-finding inquiry to determine whether Mr. Wiens was a person with a disability, and if so, to provide a reasonable accommodation. The reasonable accommodation required by the facts was appointment of counsel at public expense, and that was the Superior Court's finding. So this was this was a big win. So with GR 33 Wiens and Franco Gonzalez, we asked via petition for rulemaking that OA, Office of Administrative Hearings, do a rule that, just like GR 33 essentially, that provided a way to assess whether litigants or parties in your hearings are entitled to representation as an accommodation due to disability. So I can tell you the group of advocates, ALJs, agency reps, the governor's office was in favor of this rule, and the petition was granted, and then OAH adopted a final rule in WAC 10-24010 and implemented in January of this year. So this is just like a brand new rule, first in the country in which a rule was written, and now it's just being implemented. So it's a perfect time to bring it before you. So that's the story and the history. Johnette's going to introduce you to what the rule is at OAH, and then we're going to run some hypotheticals with you to see how you might, what would you do? That's going to be the question. What would you do? What other information would you want to know? What would you do?
There it is.
All right. Let me come over here.
Just some preliminaries, everyone. Good morning. Just a reminder, as you work on these hypotheticals, the Americans with Disabilities Act requires us to provide, as state agencies, access to our facilities and our services and programs. And for us, that means our administrative hearing process. It's not just getting in the door to the hearing room, since so many of us conduct our hearings by telephone, but it's also access to the process itself. We're required to do what is necessary. Not what's the best, but what's necessary. And so under this rule, we'll give you some more information about it later, but to set you up here, we look at what are the accommodations. First, does the person have a disability? Is this something that substantially impairs their major life activities? We've used this federal disability definition under the ADA. We ask, what are the needs to access the hearing? Now ours is already a pro se process. It's already informal by statute. The judges already have obligations to develop the record, to ask questions. Our code of ethics requires ELJs to take steps to particularly help pro se parties access the process. Most of 40,000 some appeals or more a year, I think this year it's over 50, most people represent themselves. Most people with disabilities don't ask for any accommodations because their disability doesn't limit their access. But for those who do, we look at what disabilities will work. And most of the time, even with these referrals, we find that other combination of accommodations will work. But sometimes for those clients like the gentleman with the house in Moses Lake, and you had some clients depending on your caseload and the type of hearings you do that come before you and are really challenged. So we look at two processes. One, anyone can contact the ADA coordinator. That's under subsection 7. Those are the factors. We're going to ask you to be thinking about those with these hypothetical. We also have a process where, people don't know to ask, or they didn't think to ask. And the judge is in the hearing, and maybe it's a pre-hearing conference, maybe it's at the start, maybe an agency representative calls something to your attention, maybe it's something as you've looked through the documents and that's caught your attention. Maybe you're mid-course in the hearing and something's not tracking. You're very much aware that you're going to need extra time and effort. You've tried a variety of accommodations that you've implemented on the fly right there on the spot during the hearing. And there's a process under this rule for the ALJ, on the ALJ's own motion, or at the request of any party, including the party with a disability, to raise the issue of whether this matter should be continued or stayed for a referral to the ADA coordinator. The whole thing about due process is the right to choose, even if it's to choose wrong. So, or in whatever someone's opinion is of what's right or wrong, right? The ALJ makes the offer. The person can decline and say, no, I want to proceed. And we proceed as best we're able. We all do that every day in our hearings. But if the person consents, then the matter will close, and off the record, not having anything to do with the hearing judge or ever becoming part of the hearing record, the ADA coordinator gathers information from the person and other whatever sources we can have and determine what accommodations are necessary. So with that little bit of background, give you some more later, we've got some hypotheticals, and the first one is going to be a group hypothetical. There's the first hypothetical. Do you want to read that aloud?
Sure. Yeah, so, and by the way, these hypotheticals are actually condensations of real cases. So, in the first hypothetical, appellant AB is 86 years old, partially blind and wheelchair-bound resident of Shady Acres, a nursing home in Ellensburg. AB has a pending request for hearing at the Office of Administrative Hearings to appeal a notice of discharge she got from Shady Acres. During the telephone pre-hearing conference, she tells the ALJ that she, quote, cannot read the tiny print on the discharge notice, unquote, so she has no idea why the facility wants to kick her out. She has no idea who is, quote, the guy from the nursing home who is also on the call. She tells the ALJ that she is not real good these days with dates or names. She does not want to have to leave Shady Acres and, quote, does not think I can do this hearing on my own. So we'll do this one as a group, and we want to get from you. First, do you have additional questions? We have some additional information. What would you want to know further to determine, is ABA someone either that you think needs a representation as an accommodation, or that you would refer to the ADA coordinator to make that determination? What do you think? What's your initial call? Yeah, Jamie.
I'd want to know if she had a family member or a friend who was helping her under the power of attorney.
Okay, so the question or the additional information was, does she have a family member or a friend or someone appointed under a durable power of attorney that maybe could represent her? Is that one of your questions?
Or
Good.
maybe under a guardianship.
Or guardianship. Yeah, and that issue comes up in the rule. We can talk about that in a minute. What else would you want to know? Yeah.
Just based on the specific facts, whether she's been in touch with the long-term care ombudsman who may be able to help her with some of this paperwork.
So has she been in touch with the long-term care ombudsman who might be able to help her out? Good questions. Laura?
Would she be able to read the notice if it were in larger print?
Okay, would she be able to read the notice if it were in larger print? And let's just say yes, she could. Yeah.
In that same vein, if there were any cognitive issues that affected her ability to, aside from the visual disability, but that affected her ability to comprehend.
Yeah, so are there any cognitive issues besides her visual impairments that she seems to have that could affect her ability? Yeah.
Does she have the finances to hire somebody herself?
Okay, does she have the money to hire an attorney herself? Okay, good.
How long has she been in the home?
How long has she been at Shady Acres? Okay? Yeah.
Why is she there?
Why is she at Shady Acres? What conditions and require her to need nursing home care? Other things you'd want to know? Yeah.
Why doesn't she think she can do it on her own?
Yeah. You might ask why can't you do this on your own? What's stopping you? Yeah. So these are good questions, very good questions. And what we'll tell you is this caller has an 8th grade education. She is wheelchair bound. She has cataracts that prevent her from seeing well. She has some memory and stamina issues. And let's say, she doesn't have an agent under a power of attorney, but even if she did, think about with that, or a guardian, how that might impact whether or not she should get representation. But just given those things and what we know, what do you think? How might you analyze this? What would you do? Anyone want to take it? Laura?
With regard to the stamina issue, you could have shorter sessions.
Mm-hmm. Yeah. So I think what you're getting at, she may have disabilities, right, that qualify under the ADA. Vision issues, stamina issues, mobility issues. But is there a nexus between those and the need for self-representation? And we can look at some of the factors that we looked at. Are there other things besides representation as an accommodation that might meet these issues? So one thing is with stamina, you can have shorter, have more breaks, frequent breaks, have the hearing over a 2-day period. There may be other ways to accommodate her. What else? What about her inability to read? Yeah.
You don't need representation if you can just because she has an 8th grade education doesn't mean she stopped learning.
Yeah,
So,
yeah,
would
so.
she understand enough if
So-
she had somebody that would read it for her and explain it to her?
Good, so is there, we have the suggestion she might need a reader, or I'd say also larger print might do, and then I think you were gonna say that, right? A larger print, there are other ways to.
Hold the hearing at her bedside.
Yeah, holding the hearing there where she can see you and see, and hear better what's going on and see better, yeah.
She said she doesn't understand what's going on. She's not understanding the process.
Yes.
She needs help understanding. She needs someone to represent her so she can, that can understand.
So, so then the question becomes, under the ADA, is her lack of understanding due to a disability? You have to make that connection. Or is it due to her 8th grade education, which may or may not? Are the disabilities or the impairments she has what's causing it? And if they are, you're entitled to, and meet those factors, you're entitled to representation. But if there are other ways, if they're not, then all of these accommodations that you've talked about could meet her need, even though she may not fully understand the hearing.
And let's remember also that in not being able to read the tiny print in the discharge notice, she's already at a disadvantage of being able to understand or read any of the rights information. And probably, there's no mention here about did she read the pre-hearing conference notice and the information that came with that about how to participate in the conference. We haven't yet learned also, as the judge explained the process, whether she had questions for the judge about the process. But our inkling on this one is that with other accommodations, including perhaps an in-person hearing, larger font, a reader, that she would be able to represent herself and in that process. Reasonable minds can disagree, of course, but let's move on to Hypo 2.
Good, excellent question. So Hypo 2 was a telephone hearing also involving this one denying income benefits. The appellant and agency rep both call into the agency telephone hearing successfully. However, within seconds, the appellant interrupts the ALJ, asking why the hearing judge called him. The ALJ explains the purpose of the hearing and that the appellant actually called into the conference line. A few seconds later, this conversation happens again, and the appellant explains he has short-term memory issues due to a recent head injury. His long-term memory is fine, but he forgets what happened only a few seconds before. If you were the ALJ, what else would you want to know? How would you decide? And here we thought, just to mix it up a little, as Judge Bradley said, we asked you to talk to the two or three people next to you, 2 or 3 people, and tell us what more you would want to know, or how would you decide if this is all you had?
How much time are we going to give them for that?
Just like 5 minutes.
So in groups of 2 to 4.
Yeah, what would you do? And then we'll report back.
Yeah.
why don't we come back to the folder. I'm just gonna put the rule up here, or the edited version of the rule in case it's helpful in any way, right? So that's our hope anyway. Okay, who wants to volunteer? What did you think? What else would you want to know, or how would you decide and how would you analyze it? Yeah.
Well, we started out, we had a lot of the same basic questions with the previous example, right? Does that person have somebody else to help them out, any kind of guardianship, anything like that? They were also talking about, maybe it was a recent head injury.
Yes.
So is there, maybe, the doctor would be able to provide some information, well, this is the type of thing that will resolve itself, let's say in a month. Maybe accommodate them to that extent.
So perhaps a continuance, if it's, so you want to know, they want to know, is this a changing thing? Is it, since it's recent, is this memory going to come back? Would a continuance help? What about, is there a guardian or someone else? And by the way, the rule and the ADA actually on that issue, it's quite clear that that is not relevant to, that's not relevant to the analysis of need of a representational accommodation. Whether the long-term care ombudsman could help or, unless it helps them understand it, but not to just having an agent under a power of attorney is not a suitable representative, and it's not relevant to the analysis of whether that's needed. Nor is cost, by the way, or if you can afford it. ADA accommodations, as you all know, are free, and it's not a needs-based program. So that doesn't mean someone could say, well, I want my agent under power of attorney to represent me. That's perfectly okay, but just the fact of its existence isn't part of the analysis of need, a disability that prevents self-representation. Other thoughts?
We would just want information about the nature and extent of this injury, hopefully from a doctor or some like substantive information. But if so, it does sound like something that will require representation. Kind of our takeaway.
Good. So they want to know more about the nature of the injury, maybe medical evidence of it, and then. But given what you know, assuming it's true, then you would provide. You might provide representation.
That would be our.
Because let me just ask you, what sort of, if you looked at the rule, what might be the thing that was stopping self-representation?
So you have potential disability that affects the ability to understand the proceeding and represent ourselves.
Yeah.
I don't see how you can exercise legal rights if you forgot what happened, a few moments ago. So you can forget to object, you can forget to appeal, all these different procedural steps that are necessary in representing yourself. You would not be able to exercise if you don't know what just happened a moment ago. So
good.
It's true.
Yeah, so that's sort of the granular looking at it is, does the disability, how does it relate to the ability to cross-examine, to understand, et cetera? And I think your point is, if you forget from moment to moment, it's very hard to cross-examine someone on what they just said, for example, right? Or do direct another witness. So that's how it goes specifically to representational tasks. Anyone want to add? Or, yes, you're in the back.
Well, since I'm the ALJ hearing this for the first time, what I would do is I would just continue the hearing and I would let parties know that I was making the referral to somebody else in the agency, because I don't want that person giving me personal confidential health information on a recorded line with somebody else on that line that may not be entitled to have that information.
Yes.
And so I think that's why we have that process where somebody else makes that decision,
Yeah.
just so that information is protected. And so in that instance, with that much information, I would feel very comfortable just continuing it and then referring it to the ADA coordinator.
Okay, and what this person said was she would continue, given the information, and provide it to the ADA coordinator to make that evaluation so that private information isn't given to someone who maybe shouldn't have it. I point you to section 3 of the rule here, and this is exactly what that contemplates, and Johnette is the ADA coordinator, but if you would these facts have a reasonable belief that an otherwise unrepresented party may be unable to meaningfully participate in the proceeding because of a disability. That then refer to the ADA coordinator. So those are the sort of steps that OAH has taken.
And the only thing I would add to that is the issue of consent. There was a case where a sign language interpreter didn't appear. And they waited and they waited, and there's no sign language interpreter. But the person who was deaf, actually his first language had been English, had not been deaf since birth. And when the judge suggested that they continue because the sign language interpreter hadn't come and they couldn't get one quickly, the person really objected to that continuance because it was an expedited matter and they would be harmed if it was not heard quickly. So the judge, learning that the person could read and write, worked with the agency rep. They found a room with a computer and all three of them gathered around it, and the entire hearing was done in writing with everyone typing onto the screen, and the judge wrote his explanations and questions. The parties wrote their questions, they wrote their answers, they did the hearing, and the judge was able to make the ruling. So the process is that that person may not want a continuance. And you don't necessarily have to go into all the information about their disability, as much as saying, I've noticed what it is you've noticed, briefly, factually, and ask if you're thinking about continuing this matter to have the ADA coordinator talk with them confidentially, and giving them that opportunity to participate in that affirmation, so that then when the ADA coordinator calls, that they're expecting the call and they've consented to the continuance. Yes?
Could you give us some ideas of what do you do in a situation where, say, the ALJ observes some behavior and is a little bit concerned that there may be an ADA issue, and gently brings up the topic, such as it seems like you might be a little bit confused, and the person says, no, I'm just fine, blah, 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 and is not giving you any hint that they'd be interested in a continuance or a referral to the ADA coordinator, but the ALJ is very concerned about this person's ability to meaningfully participate. What do you do?
So the question is, if the ALJ has become concerned about the person's ability to participate and note comments that I've noticed you were confused, the person says, no, I'm not, wants to go forward, what should the ALJ do? So part of that task is being creative about the way to ask a question. So be specific. I noticed that when I explained this process to you, or when you referred to this exhibit, you've repeated that 3 times, even after I gave you an instruction or something specific, so that you could find out, was there a point that you're missing? It might be you. Maybe they're trying to make a point and they're just not doing it very well. Maybe they were up all night, or they've just started a new medication, and it's a temporary matter. Maybe they just need a short break. But if it's something more, I think it's try to be as specific as possible. And then the other is simply say, we accommodate people with disabilities. We refer parties to our ADA coordinator who talks to them confidentially. Would you like me to stop this process so that you have a chance to talk to the ADA coordinator? They could be in touch with you today or tomorrow, or something like that. Then you're giving them that opportunity. But it's not something that we force on individuals. So it is a challenge. Yes?
So what if they say no?
Then you do the darn best you can, just like we did before we had the rule. Yes?
I actually had a moment where it was, I wound up getting consent, but between the language barrier and the mental capacity barrier, it was hard to even get any kind of comprehensible response from this appellant.
And they're talking about when, with a language barrier and a comprehension or cognitive barrier, it's hard to get any real response. And we purposely did not define consent. It's not informed consent. It's the sense of them giving their agreement. So partly it's thinking of different ways to ask by saying that We sometimes modify processes. We even sometimes appoint a representative to help you. Would you like us to consider that for you? Or something like that. And if they still say no, then you just do the best you're able. It doesn't mean that as the hearing goes on and you're indicating that there's material that they haven't provided, questions they haven't asked that you've asked, and documentation that isn't there, that you can either give them extra time to provide that documentation if they have it, or re-ask again. I've noticed now we're almost at the end of the hearing and you haven't offered any evidence on these points. I'd sure like to have that evidence in making my decision. You know, do you have a way to send it to me? Or again, would you like to talk to our ADA coordinator or something like that? But otherwise, you have to go forward.
Well, and I guess a follow-up question to that is, if I had not been able to get because I mean, it really came down to, the interpreter was saying, she's not even making any sense at this point, I can't even interpret what she has said. And I was eventually able to get that response from her, can I have someone call you to see if you need some help? I mean, I had to put it that simply. But if I'd gotten neither a yes nor a no, because it was looking that way for a while, should I have forwarded that to you regardless?
Well, I think the question is, if it came to where, you know, really she couldn't get a yes or a no, should that be forwarded to a coordinator or someone regardless? I think it depends on the stage. If you're at a pre-hearing conference, you can go ahead and set your dates for hearing, do what you need to do with the pro se party, but give the ADA coordinator and your supervisor a heads up, and that way the ADA coordinator can reach out and say, I was asked to follow up with you. You also are learning to, is this a language issue? Is this a dialect issue? Is it the dialect not coming through on the telephone? Sometimes it is really the language that's the issue, and we need to learn more about the interpreter and the specific dialect. I bet you two have held a hearing where your interpreter lets you know at some point that, you know, this is really rudimentary. This person has the most crude, elementary, basic language skills. That's always also an opportunity to follow through.
Can I just add one quick thing? First, I want to commend you for staying with it. And those are the hardest cases and probably the least frequent that come up, which is where the person's seem either too disabled to even consent, right? And we spent zillions of hours trying to figure out what to do, including appointing a guardian ad litem. I mean, zillions of hours, but it is the least frequent. I think you err on the side. One, I think you always mention the possibility of representation as an accommodation. Don't hide that, because people don't know that that is a possibility. And I think that okay, and then you may get it, so I would recommend that. And second, then I would refer it if you're not sure. And then they can deny consent or go to the ADA coordinator. I would err on that side.
And just on that point of consent, we have had some referrals where other individuals filed a request for hearing. Social workers at a skilled nursing home. Someone was almost 99 years old, and everyone that she had designated to speak on her behalf had unfortunately passed away. She'd outlived them all. She was not able to speak, was nearly comatose, and had advanced dementia. So even though we couldn't get consent, we found some alternatives working with the state agency to use their subpoena powers to get the bank information that nobody could get, to get her financially qualified so that they could move forward and figure out if she was functionally eligible. So there are some processes that can happen now.
You guys are great. Yeah, let's go to the third. We have one more, oops, we're going backwards. One more hypothetical for you to work through with your group. This is an in-person food assistance hearing. The appellant's food amount was reduced because she did not provide proof of her rental payment. A portion of housing costs can be deducted from income to determine the amount of food stamps you get. But, so the appellant is pleasant, she stops talking when spoken to, but everything she says is regarding aliens, government surveillance, implants in her brain, and Obama speaking to her telepathically. She answers direct yes or no questions, but then immediately discusses her favorite topics as though they are related to the question. The ALJ asks her if she knows why she is here. She says yes and starts rambling again about aliens, implants, and Obama. However, as she rambles, she hands over her subsidized housing rental statement, which shows proof of her rental payment amount. So now that she's provided that evidence, what should you do? Complete the hearing, take other action. Why don't you take a couple of minutes just to talk in your previous group since you did so well, and then we'll come back and see what would you
Thank you, everyone. We're thrilled that you're enjoying the opportunity to really talk about these examples. We hope that gives some real life, even if I'm guessing very few of us are actually millennials. I'm sure not. Input, what would you do? Would you complete the hearing? Would you take some other action? Yes, Mary Ellen.
Try to resolve it with the department rep. Got the information, based on this information that you have, do you think you could resolve this? Take a break, let them talk to their supervisor and see if you can resolve it.
So one idea is, now that you have this evidence, ask the department representative if they want to review this and does this resolve the issue. Give the department the opportunity to change their position and make a motion. Thank you. Yes, Laura.
I think you can, at that point, go ahead with the hearing. The person is able to answer some questions, so confirm that that's the current lease, it's their signature on it, make sure that it's good evidence. And if that was the basis for reducing the food stamps, we were talking about if you're actually able to provide the benefit, then that's probably in the person's best interest.
Yes, that was the missing piece of evidence, and Laura's suggesting, provided the person's able to identify that that's their signature, that's their lease, that's their agreement. If that is indeed the missing evidence, then the other irrelevant information doesn't prevent you from go ahead and proceeding to make a decision.
Yeah, and I think the purpose, and we agreed, and that's what the ALJ did. The purpose of this one is to show this is a person likely with some severe mental health disability, right? Yet, let me just finish that and I'll check with you. Yet, there has to be a nexus between that disability and the ability to self-represent. And here, she was able to focus when talked to. She actually was responsive to she seemed to understand the issue and was responsive with the very piece of information that may have resolved the case. So we have a severe disability, qualifies as a disability, but she still was able to self-represent. I mean, that's sort of how the analysis went. She was still able to do the things. So that's where we fell, where we came out as well. Anyone, you wanted to add something?
Well, I just wanted to, she was able to provide what was needed, so I think you're going to resolve the issue. Mm-hmm. But as an ALJ, do we have a responsibility to make a mental health referral? And it seems to me like you're stepping outside the bounds of your responsibility. So you can suggest that. What would a referral to ADA do?
So to the ADA coordinator or to some other service?
Right.
Well, if you thought, I think you would if you thought, at least for a representational accommodation, if you thought her disability, mental disability, interfered with her ability to self-represent. You would have that obligation.
And the question also addressed, well, even if you resolve the hearing, is there some obligation to make a mental health referral? My perspective is that when suicide or someone's threatening to take their own life or do some self-harm or self-harm, then it's appropriate to make a reference to suicide prevention, to have someone follow up. We've asked for local police to go out to do a welfare check. When it's harm for others, that's the same thing of making those kinds of referrals. Those referrals you would want to talk to your supervisor about to see, or contact a deputy chief, who's ever responsible in your agency, your ADA coordinator. When you need to and you're out in the field, you make the call yourself, safety's first. But with otherwise, I generally would think that referrals to adult protective services, to mental health, those are usually more of local mental health is involuntary. So you'd need a lot more information that you have on the record here for that. And it's hard to make a mental health referral without going into a lot more information on the record that's confidential, that the party probably doesn't have an obligation. It might depend on the case. If it's the healthcare authority, you might already know that they're receiving mental health services, even though this case is about food assistance. But if it's an unemployment insurance hearing, it's about revenue. It is about a license. There's no need for that other party to know all of this healthcare information. And so those are the balancing tasks that I'd have in mind. Anything else before we move on? Yes, Laura? Oh.
I was just going to mention, Johnette, that one of the things we've done in our agency is provided the judges with information about the community action programs, so that when people are having issues such as housing, food insecurity, that are not directly related to what we need to decide. We don't diagnose, but we say, here's an agency that can talk to you about those issues and get you to the right place.
Here's good information at the Board of Industrial Insurance Appeals. The judges have access to community action information, where people can get resources that are not related to the issue before the judge, but issues about housing, food assistance, and the like. So that would be something that you might find useful in your own agency, or as that varies from region to region. There was something on this side? Yes.
So I was just, going back to issues of confidentiality, and you're addressing the issue in front of you with regard to whether or not there needs to be some representation, but you're also concerned generally whether it's self-harm or harm to others. How do you navigate that piece? If this proceeding is confidential, how do you make those referrals to the mental health professional or APA, assuming it's outside of kind of the healthcare rubric? Is it the coordinator that does it? Are there special agreements?
You know, I'm not, the question is, how do you make these referrals within the context of this, of matters being confidential? I'm not aware of anyone who's making referrals to mental health or any other organizations on their own. The only referrals of which I'm aware are when there is someone openly says on the record information about thinking of killing themselves or harming someone else. So when they're on the record about self-harm, that's a really difficult thing to talk about. I mean, it's hard to even know what to say because that's sometimes I have actually heard some records where judges have actually engaged the person, like, you know, to try to say, well, no, let's back you up and finish the process, and is there other, maybe talked about who else that they can talk to. Some other judges have encouraged the person to call that when the hearing's over, do you need to take a break from the hearing? Do you need to get some help? And others have just not been sure whether it was serious or not. We don't judge whether it's serious. And the other issue is it's not for the judge to determine if the person's disabled, just if they might be disabled. Does it appear they are? And pointing out what those facts are that you've observed, really right, as Laura said, right to the point. Like, I've noticed such and such. Do you have some explanation for that? Oftentimes people will tell you then what the problem is, and you can say, would you like, and so there's that opportunity. But I'm not aware, is any other agency, this is kind of leading into our next part about what other agencies do. Do other agencies have a formal policy or even informal policy or practice about referring the members of the public that you deal with to mental health or for police action?
This is a NAA Healthcare Authority. We have, depending on which part of the agency, we get the phone call, and we have multiple call centers. Also within the different areas that engage directly with adjudicated proceedings, we'll be dealing with the public. And we have informal policies and procedures and practices to make those referrals out to for a wellness check. I've personally had to work with staff to do that before, when a person says they're in the shower naked and going to kill themselves unless we give them their oxycontin or whatever. And we've had to send the police out their do a wellness check. So we don't have as much as I would like to see across the organization of having well-written policies about that and agency-wide procedures. It's a little bit more ad hoc based in the business unit.
Thank you, Annette. Annette is explaining that on more of an ad hoc basis, they will refer for a wellness check. Her example was someone's calling in indicating they're in the shower naked and they're going to kill themselves if they don't get their OxyContin. Or, you know, that's an example that they would make a welfare check to have the police go out and, or someone go out and, it's law enforcement?
Law enforcement. You also keep them on the phone until the law enforcement gets there to ensure that they aren't doing something. So we place, you know, train staff so that they know, keep the caller on the phone, have somebody next to you to be making the call to law enforcement, and so it's kind of dual, a buddy system.
So they train their staff to keep the person on the phone, and a buddy system, someone else is calling for a welfare check for the person, and the other person tries to keep them on the phone and keep them calm and keep no self-harm until the police arrive.
Can we find out what people are doing in terms of accommodations in these situations?
Yeah, and one more.
Oh, I just had a question. How would you deal with the record? You know, you've got the tape going or whatever, you're recording the hearing. But what if there are some really, you start to get into that kind of a thing, there's somebody else on that phone there who really isn't entitled to that information. How do you deal with the confidentiality concerns of the following?
Well, the question is, when you have two parties on the phone, how do you deal with the confidentiality and concerns of the appellant? By the way, Annette's example was, it's just the agency representative and the customer, the applicant or recipient of their benefits who's on the phone with them. But in a hearing, remember, this is the statements of the person themselves. There's no confidentiality in terms of what they choose to say themselves. And that's why I was asking if you had policies or procedures, because that's a difficult choice where the person themselves has made the disclosure to everyone who's on the record. And it's a serious life matter, or it's a death threat to the other party, or something like that. Then safety, for the most part, is the primary concern, and they've already disclosed the statement themselves.
But this is precisely why we have this accommodation process. In the first instance, people can ask prior to the hearing for representation as an accommodation. That may be the way it happens. The accommodation process is completely private and separate, not in the record of the hearing. So that's the way it should work in the best of all cases, right? And if you're suspecting, if you have a reasonable belief that an unrepresented person is unable to participate, and you can check with them, get their consent, but from there, you can continue the hearing and refer to the ADA coordinator. Also, they're off the record and it's not part of the hearing record, that part. So that's how the process was, was anticipated.
Yes, you can certainly comment about the stress of the situation and understand that these hearings can be stressful. Would you like to take a break? I'm really concerned about these comments you've made about feeling like it's the end of everything. We have an ADA coordinator be happy to talk to you so that you could get through this process and move on to the next day if you're feeling really so stressed this day. Now, you could do that in addition to perhaps making a welfare check. One more question, Sherry?
Aren't we really talking about two different things? One, safety issues, and the other is an ADA issue.
We are.
And I think that it would be helpful for the agencies to come up with a protocol to deal with safety issues, because sometimes those you need to make split-second decisions rather than trying to find a supervisor or somebody else to make that decision for you. And so,
yes.
Great.
Yeah, we totally agree, and but also a protocol for the ADA accommodation. I mean, this OAH's rule is one rule for a certain number of agencies, and one thing we were curious about is, what about the non-OAH agencies that are here? How are you dealing with, not the danger issues, but the accommodation issues we raised in the hypothetical? What would happen in your agency? Are there rules or internal policies or nothing? How are you dealing with it? This was, we're curious. Or would you do something different now that you're more, as our learning goals said, more sort of in tune to the issue? Laura.
So at the BIA, instead of enacting a WAC, we have a policy signed by the 3 board members that lays out the process. We have forms on the internet where people can formally request accommodation. I'm the coordinator, so I review those. I have a committee that I work with. I respond, and then if a person's dissatisfied with my response, they can appeal to the 3 board members for another look at it.
So the BIA has an internal policy, not a rule, in which accommodations are done, and Laura, as the coordinator, makes those decisions, and there's an appeal to the 3 board member. Does it include representation as one of the accommodations?
It doesn't specifically include it, but it does not exclude it.
Okay, so that would be considered, yes.
My follow-up question is, do you have a pool of representatives that you can select from?
Not at this time, no.
And that's an issue with OAH too. They now have a pool. Oh, yes, the question was, is there a pool of representatives to refer to? I have advocated that contract should be led through to a legal aid organization ready to do it, that are already trained. That hasn't happened yet, but I'm hopeful because that's a big, big issue, and volunteers don't tend to aren't readily available and not necessarily ready to do this. So that's still a very big issue. This just passed in January, and we're still working on that the implementation is not as easy as, it's not easy, or is easy, but it's not happening yet.
Sharon? I have a quick thought on that, is that the person who represents a person in an administrative hearing does not have to be an attorney.
That's right.
And just a thought, this might be a great opportunity to develop a legal clinic at a law school and have students do it.
As someone who runs the law clinic, yeah, we've certainly been approached by that, but it's actually quite, quite I think that's a sort of one-off potential, but I don't think it's an ongoing.
Right.
So it's true, you don't have to be lawyers, but you need to have training to meet just like you don't just bring any sign language person off the street, right? So they have to meet some qualification, so paralegals can do it. I just find that the easiest way is when we have legal aid organizations with paralegals ready to do it and trained, that seems a reasonable way.
Just a quick caveat, I think the lay representation, the ability for lay representation is agency specific. Our agency doesn't allow for lay
That's right.
representation. You have to be an attorney, with the exception of one program, you have to be an attorney to represent a party. As for what our agency is doing, we have a public accommodations process now with, they can appeal to the NAA coordinator.
Yes.
We haven't gone as far as it's still, there's no 100% agreement as far as the opportunity for counsel, but we do have a public accommodations process.
Great, thank you. From the Department of Health, Roman just said whether an attorney is required is agency specific, and at the Department of Health, they require in all except for one set of hearings attorneys. So the reasonable accommodation would be an attorney in all of those, not a paralegal or anyone else. They have a process, an ADA process. It's still in process about whether a reasonable accommodation of a representation would be allowed. We hope you move in that direction and find that all the barriers that everyone worries about don't in fact happen. So.
Our time is nearly up, so I wanted to share hopefully maybe a few more questions, but also I'll send the final link when this is ready so that attendees have access to it. We've made a training program for a network, as our network is evolving, a network of individuals who would be interested in doing this work. Sometimes there are GR33 attorneys who've been appointed, and the client also has an administrative hearing, and they have graciously stepped up and represented their client. This is an online self-paced program. Excuse me, it's available on our public website. So while it's for suitable representative, it's available to anyone. And in the interest of time, I'm just going to scroll through. There are some of the materials that are part of your overall materials. They include this document on the role and responsibilities of a suitable rep. Thank you. Role and responsibilities of a suitable rep. And also, there's a 2-page overview of the rule. We hadn't heard Laura's presentation, so this rule is dense. It's 4 pages, single-spaced. It can be a little off-putting. It includes training requirements. It includes a 2-year period of gathering feedback and review. That's what we just gave you, the one part of section 3 and subsection 7. That 2-page summary of the rule and the history and where we go from here is part of your materials. And then I wanted to show you that We broke this up into modules. There's a specific module for learning how to advocate for people with disabilities. And we have both videos, they're on YouTube, they're closed captioned if you want. All the documents are accessible for screen readers or for other assistive technology or devices. We also then have a section. For each of these sections, the rule requires that you either have uniform qualification training or equivalent experience or training. And that can be in any of the subsections. So one is on working with individuals with disabilities. The other is on the procedural rules. And so we cover both certain specific sections of the APA. Now, not all of you are APA agencies. And we also have optional to read the entire APA for those who are really, really gung-ho. Then we're also going to have the opportunity to look at some mock hearing videos. There's also the opportunity later to arrange to either sit in or listen to a live hearing. And then we have one on substantive law. We have relied on the resources that are already available through Washington Law Help, through the State Bar Association, through the State Law Library, through the various agencies. So these are all hyperlinks. And in our videos, the videos are for the most part for millennials in the sense, I haven't thought about it, but a millennial and I co-wrote them, and they have graphics and bullet points. But at the end of every video, it says, if you're not familiar with hyperlinks, if you're not familiar with how to search the web, stay on. So you can end the video if you know that, or you can stay on for instructions about how to use this checklist, how to navigate YouTube, and that kind of information. We also then have a list of resources. No sense of getting really detailed about every single type of agency case that could come before you if you don't have the case. It's not value to your time. So we have links for information that they'll follow up on when they're actually assigned a case. And we give them examples of where to get information. Then we also have a whole list of resources here. Some are general resources. This whole group will add to it. If you have ideas about articles or videos that you think would be helpful, I'd love to post them. I'm going to try and find from Laura that link to the bench guide for working with people with disabilities. I don't think I have that link here. So our time is up. I don't think we have time for questions, but we do want to thank you for your attention and your participation.